This is a criminal case in which a man's liberty and entire life has been consumed by 4 years of litigation that the executive has now determined within its sole discretion should never have been brought against him. He has been under the scourge of this criminal process now for almost 4 years. Mr. Gleason has no valid role here whatsoever. It's the process itself since May 7th that has been part of the abuse that General Flynn has suffered. These are completely unprecedented proceedings, and the reason they are is because they should never have happened. Mandamus doesn't need to have an order to seek review of it. Its very purpose in existence is to correct a usurpation of power or the district judge exceeding his authority, which he did the very minute he appointed Mr. Gleason to step into this case in the role of a prosecutor, essentially, when the executive branch, in its sole discretion, decided this case should never have been brought to begin with. So he's been through this for almost 4 years now, cost him millions of dollars, had to sell his house because of it, been called a traitor and treasonous for absolutely no reason, and not any of this should have happened. So it is imperative that this court restore the rule of law and issue the writ of mandamus to compel the judge to grant the motion to dismiss and to disqualify Judge Sullivan, because the very fact that he thinks he has an interest that he can petition for rehearing to this court on is sufficient evidence of appearance of bias that mandates his disqualification under this court's decision in al-Nashiri. The appointment of the amicus has to be vacated, and the order must be dismissed immediately as a matter of law on the face of the motion itself. To borrow from the Second Circuit decision in HSBC, put simply, the court's role is not as a super prosecutor to second-guess a core function of the executive branch, but as a neutral arbiter of law. He's lost that neutrality, if not sooner, then at least by the time he filed a petition for rehearing, in which he has no standing and which has required additional 1,000 hours of defense work to deal with. We ask that the petition for rehearing be flatly denied with clear Ligon-like language and the order of dismissal entered in stanter or by this court itself as it has the authority to do.